requirements class. This is some literary practice for the record. Mr. President, stress is a byproduct of our complex society, which makes many tangible and intangible demands on all of us. Families which in simpler days provided refuge from the demands of everyday life, unfortunately, are no longer immune from the adverse effects of stress. Peaceful communications and harmony have given way in thousands of households to physical and mental abuse between spouses. Domestic violence threatens the well-being of millions of people. Congressional witnesses indicated that between 1.8 million and 3.5 million women are abused each year by their husbands, and that 1 out of every 6 couples in the country experience some violence during the year. A large number of children and elderly persons are also victims of serious abuse in their homes. Family violence is not an isolated occurrence or restricted to any particular locale or group of people. It is a phenomenon that knows no boundaries. Like other social diseases, domestic violence can be treated. The primary victims of domestic violence, most often women and their children, need safe places to go for short periods of time so that they can make plans either to begin new lives or to return to their homes to work out their interspousal problems. Many of these women also need counseling and other assistance to help them make the transition out of the family or to help them return to their homes. The physically abused woman is not the only victim of violence. The person inflicting pain and misery is the other victim. This person, most often the husband, needs help in understanding why he takes his tensions and aggressions out on his loved ones so that he can control this behavior. Help for both victims of domestic violence will make it possible for husbands and wives to restore domestic tranquility. This in turn will rescue marriages that may otherwise have failed and save countless families along the way. While I would like to be able to report that the people of my own state have not experienced family violence, this simply is not the case. A recently formed statewide coalition on family violence and sexual assault presented the case of some 4,000 to 6,000 families afflicted by chronic misdemeanor or felonious battery in the family to the Wyoming Conference on the Family. The coordinator of the coalition informed me that the conference responded by passing their only unanimous resolution citing the need for a state shelter and treatment system for the perpetrators of family violence. While 8 sexual assault family violence projects have recently been undertaken throughout the state, each one of these programs needs a secure source of funding to get through its initial phase of operation. The legislation before us will provide support from the federal government for these and other programs like them, and will enable them to provide services to victims of family violence while developing independent funding sources for their future operation. Mr. President, I support the Domestic Violence Prevention and Services Act before us now and intend to vote for it. Title I of the bill as amended will provide needed funds for state, local, and community activities to prevent domestic violence and to provide immediate shelter and other assistance to the victims of family violence. The legislation has been improved through a series of constructive amendments offered on the floor during consideration of the measure. These amendments resolve many concerns I had and which have been expressed by people across this country who did not want a bill that would thrust the federal government on the family. Some concerns were raised about the federal government imposing domestic violence programs on unwilling states or communities. The bill does not give the federal government the right or the power to intrude uninvited into state or local affairs. If a state wishes to participate in the federal grant program, it can submit an application to the Secretary of the Department of Health and Human Services. It is not required to participate. In addition, a floor amendment adopted by the Senate provides that the state legislature must be given written notice of any grant to the state under this program. Thus, even after the state has voluntarily submitted a plan, the state legislature can take steps to prohibit participation in the program if it so desires. Importantly, the bill was also amended to prohibit direct federal grants to private nonprofit local organizations. According to the amendments, the Secretary can make grants only to the state or to units of general local government, cities and counties, and not to private entities. Okay, this will be some legal material for the record. Madam Foreman and ladies and gentlemen of the jury, it is now my duty to charge you in the law in this case. It is always gratifying when jurors show an intelligent interest in the evidence because the law of Oklahoma makes you and you alone the sole judges of the facts, the truth, or want of truth of testimony. I am not allowed to intimate to you any opinion that I have along that line. That is your special province under the Constitution of our state, and if by chance you should gather any inference whatsoever from any remark or any ruling that I made as to the facts in the case, you would of course disregard such inference because you and you alone are the sole judges of the facts and the credibility of the witnesses. Now, the state of Oklahoma charges this defendant with assault and battery with intent to kill. To that indictment, he has pleaded not guilty. And it is a cardinal and important rule of the law of evidence that the defendant in a criminal trial, no matter what may be the enormity of the crime charged against that person, must always be presumed to be innocent of the crime for which he is indicted until his guilt has been proved beyond a reasonable doubt. Now, this presumption of innocence does not cease when you retire, but it accompanies the accused from the time of his arrest throughout the trial and until the jury has reached a verdict of guilt based upon all the testimony to the exclusion of every reasonable doubt. It is the solemn duty of you, the jury, if not clearly convinced beyond a reasonable doubt to the contrary, to reconcile the facts proved with this presumption of innocence and acquit the accused. Our state's Supreme Court has said in one of its decisions that this presumption of innocence accompanies the defendant from the moment of his arrest and clothes him as with a garment until a verdict of guilt has stripped the presumptive robe of righteousness from this person. So at this time, he is entitled to recognition as a member of that class to which the presumption assigns him, the innocent and not the guilty. This legal presumption of innocence is to be regarded by you, the jury, in every case as a matter of evidence to the benefit to which the party on trial is entitled. Therefore, the accused in this case is presumed under the law to be innocent of the offense charged against him in this bill of indictment. And this presumption of innocence is not legal or judicial fiction, but a vital and substantial legal right which justly entitles him to an acquittal at the hands of you, the jury, at every stage of this trial until the finding of the verdict, until it is proved by evidence in this case sufficient in force to convince each and shall of you jurors of his guilt beyond a reasonable doubt. So I say this burden placed upon the state rests upon the state throughout the trial until the state has satisfied you by evidence of the defendant's guilt.